why has e-discovery made it more difficult for our current judicial system to operate? Why has it blown the costs out of the roof? Why has it resulted in delay? Why are cases now being settled? Because it's too expensive to do e-discovery. That's the question, and the real answer comes again by looking at society at large. We've gone through most incredible technological change and accelerated development of inventions and information processing in the history of the world. We have very rapidly, in the space of 20, 30 years at most, totally transformed from a paper-based society into an electronic, digital-based society, and have changed our form of record keeping from paper to digital. Now, this has created the challenges, this has created the expenses, this technological revolution. And with the technological revolution has come an explosion of information in the volume of information that we have. So this is the fundamental reason that we now have e-discovery as a discipline, and why we have it as a fundamental problem is because of the technological changes that we've gone through. Tremendous opportunities, tremendous advancement that has been opened up by having computers everywhere, but also the problems, particularly the problems facing a intentionally conservative institution like the law that has been working for centuries in a paper environment, that has been working for centuries with paper documents and paper evidence. We built all our rules around that, we built all our procedures around that, and frankly, that's what most lawyers my age know how to do, is discover paper. And that's what we learned from the generation before us, and then the generation before them, going back really hundreds of years. Time of Abe Lincoln dealt with paper contracts, paper documents. May have been handwritten until the typewriter was developed, but it was paper. We saw an explosion in the amount of paper in the 60s and 70s and 80s with the advent of the Xerox machine, which, by the way, was invented by a patent lawyer in New York. But still, it was paper, and we knew how to deal with paper, and we were able to adjust and keep discovery going, albeit it did become more expensive when, instead of having one or two filing cabinets with paper, there would sometimes be hundreds, maybe thousands, maybe warehouses filled with paper in large projects, construction projects, things like that. But still, we knew how to sort and go through and search and find paper evidence. All of this started to change in the early 90s, and in the turn of the century. And in the last, I'm now speaking to you, it's the end of 2009. In the last 5 or 6 years, the change has accelerated. It's been a bell curve. It's starting to go up. Every time it goes up, exponentially it doubles, which means significantly more change. We are now in the period of time where there is significantly more change in information processing, information storage, the technologies underlying it, than there have been at any time in our lives before. And there appears to be no end in sight of this rapid acceleration and change, of this rapid transformation, not only from paper to digital, which at this point is pretty much complete. Maybe 98% of our writings are digital. There might be 2% that's still paper, lawyers scribbling on legal pads or something. But most of our information, our writings, is generated electronically, and the originals are electronic, not paper at all. But what is changing now is the electronic forms themselves are becoming more diversified, and they're spreading out, and they're getting more complicated. This is, again, increasing the challenge of lawyers to find the information they need in order to find out what happened in the past. What were the facts? We listen to witnesses. Frequently, I would say almost every lawsuit, there's some divergence in testimony among the witnesses. One side says one thing, the other says another thing entirely. You can, through testimony, you can start to figure out where the differences are, hone in on the issues, but then who are you to believe? This becomes a credibility factor. And that's where the writings become critical. They've always been critical. The paper writings have always been the foundation of evidence upon which we can resolve the disputes in testimony, which is why the law, particularly in the 20th century and the turn of the century, has always focused on discovering what were the people putting down in writing, what were they expressing in a written language, because that's the best indicator of what was really happening. Not the vagaries of memory about, oh, here's what I remember happened. Because we all know that memory is self-serving and is not reliable, and there is always a tendency to slant a memory in order to favor your current position. The only real indicator is what did you say back then, and that's where we come into the writings, and that's where we now come into the writings that we're going to the history we're trying to unlock and uncover what really happened as lawyers means going into the digital world, going into the electronic writings. And this is where the problem and the challenge lies, because this digital world, this ever-growing information explosion, involves complexities in technological understanding and training that we as lawyers have never had before. It hasn't been offered in law school until just recently, and it hasn't really been part of most law firms' cultural and training from one generation to the next. That's because the current generation is really the first generation to face it. They're not having the advice and the help from their senior shareholders, senior partners in most firms, so they're having to do it on their own. As a result of the lack of experience, as a result of this ever-changing, rapidly moving, accelerating explosion of forms of writing, the complexities of information, the difficulty in finding the information when you have hundreds of thousands of letters, of emails, instead of just hundreds or maybe thousands. When you have this exponentially increasing amount of information, it becomes harder to locate the relevant information that you need as a lawyer to find out what really happened in the past, so that you can do justice for your client, so that you can put on a case in front of a judge and jury that is credible and that resolves the differences in testimony between the witnesses, so that we can get at the truth. So this is why e-discovery has become the fundamental critical problem, is that these writings are the foundation of the truth needed to resolve disputes in the legal process in our judicial system. And yet, most lawyers today are not really able to get at and find and retrieve or understand most of the electronic writings. Not that they can't read it, but understand the format, where it's located, its filing system, or its default storage system, because most electronic documents today are not consciously filed. They just automatically get put places in vast computer systems that may be spread out all over the world. They may be stored in a small portable electronic device. They may be stored in a personal computer or in a laptop or on the computer network of their company. They may well be stored on an iPhone, other portable digital assistant device, may be stored in the clouds, and the ever-growing proliferation of websites where information is created by individuals all over the world. You know, there's over a trillion websites now, so trying to find the information you need is literally the search for the needle in the haystack. This is a search that so far has overwhelmed the legal profession. We have not figured out a way to do this yet. We are working on it, but one thing we know for sure is that we must up our game and up our own understanding of technology, of how modern writings are created and stored and generated, which means understanding our information technologies, working hand in hand with law and IT. And this is not something that is currently offered in law schools. I doubt it's going to happen anytime soon, which is why we need to have new educational programs that harness this technology. And I'm talking about cloud-based online educational programs that allow us to disseminate the information that we have learned the hard way, that we have figured out, the best practices that we know how to get at this information and how to collect it in a way that's forensically sound and get it into the courtroom so that we can resolve the disputes and testimony and do justice and do it in a way that's affordable and that's speedy and efficient. And that's what we need to do in order to keep our judicial system running, is get this e-discovery under control by sharing the information that we are learning on how to do it properly, and getting this information out to as many attorneys in the trial arena as quickly as we can before we drive away more and more litigants to alternative forms which are not going to allow us to continue our tradition in American law of resolving courts in a fair and just way inside the courtroom instead of in the arbitration panels or on the street.